Be ready. Start. The recording of evidence of a witness in his chief examination shall be by affidavit of the said witness, and a copy of it shall be furnished to the opposite party when documents are filed in court along with the affidavit. The relevancy and admissibility of such documents has to be determined by court. The cross examination can be done in the presence of presiding officer of the court or get it recorded by a commissioner to be appointed by court out of panel of commissioners prepared by the district court or the high court. The remuneration to be given to commissioner for this purpose can be fixed by the court. The court can appoint a commissioner for examination of witness residing within the local limits of his jurisdiction. Wide Section 29 of Amendment Act 46 of 1999. During the examination of witness, the court receives objection as to a question as leading, irrelevant, inadmissible, etc. Many a time the court also is confronted with objection about admissibility of documents on the grounds of non-registration, unstamped or understamped, unproved, exhibited without proper foundation, unattested, etc. The court is expected to hear both sides in such a case and shall overrule or sustain objection by giving reasons either in the deposition or by a separate order. The circular issued by AP High Court shows that all objections shall be answered by the court and that the court shall not record evidence or exhibit documents subject to objection to be decided at the time of disposal of the suit. In practice, for a variety of reasons, the courts have been recording evidence and exhibiting documents subject to objection and deciding them at the time of disposal of the case. It is not uncommon for an advocate to request the court to record the evidence or exhibit the document subject to the objection. Vigilance is required of the judges while admitting a document and marking the same as exhibit. Usually, the judges believe the advocates, and when the other side is even absent, judges often, in good faith, take up evidence and keep the same for cross examination. In such evidence, when the adversary is absent, the lawyer gets all the inadmissible documents marked, and once the inadmissible document is marked as exhibit, it becomes a valid document in law. Such ingenious acts jeopardizes the judicial work, and no higher court is prepared to accept that the document being inadmissible have even inadvertently marked to be strike out. It is good if judges are very careful in such adventures, and is advisable with great respect that judges should not make document in the absence of the other side advocate. It is respectfully submitted that the law should be amended to make such documents withstand the test of admissibility, even they are marked in quixotic manner. The court also has power to record the demeanor of the witness, but courts do not usually record it unless it find it necessary to record the demeanor. Either side's counsel may also request the court to record the demeanor of witness. If the court is satisfied, it may record the demeanor of the witness in the deposition itself. A party may pray for recall an already examined witness for further examination or further re-examination. The court may entertain such a request in appropriate cases. That apart, the court may suo motu recall any witness at any time to question him further. Apart from the chief examination, cross-examination and re-examination, the court may examine the witness at any time, putting any question to the witness whether such a question is relevant or not and admissible or not.